Good. Mr. Ling, good to see you. Do we have Ms. Wagner? See Ms. Wagner is connecting to audio.
1, 2, 3. Good afternoon, Mr. Chair. Just want to test my audio. Okay.
I can hear you. I can hear you. Ms. Wagner, are you there? I see it.
Am apparently.
Oh, great. Hey,
There I am.
there you are. There you are. Excellent. Thanks very much. Okay, is there any reason we can't get started?
None on my part.
Great. Okay, so as everybody knows, this is the Board on Professional Responsibility. Today is June 9th, and we are here in the matter of Brenda Carol Wagner. This is board docket number 20-BD-59, disciplinary docket 2016-D82. So why don't we start by having the parties identify themselves for the record. Let's start with disciplinary counsel, Mr. Link.
Thank you, Mr. Chair. My name is Miles Link. I'm representing the Office of Disciplinary Counsel.
Excellent. And for a respondent, Ms. Wagner?
Brenda Wagner, the respondent.
Excellent. Thanks. So a couple of housekeeping things. First, the record should show that Alyssa Preheim, who's one of our attorney members, is recused from this matter, so she'll not be participating in the case. Also, Sandeep Hora, who is one of our attorney members, is not with us today. Under our board rules, it's Rule 13.6, an absent member can participate in the decision by listening to the recording of the oral argument unless the respondent objects. So I guess, Ms. Wagner, do you object?
No objection.
Excellent, thanks. Okay, so as a preliminary matter, I know that there are two pending motions. One of those, it looks like disciplinary counsel, the time to file a response to that has not expired. For both of those motions, we will not be ruling on them today. We're going to take them in, under advisement and rule on them in the course of the report and recommendation we anticipate issuing in the case.
Mr. Chair, I believe disciplinary counsel has filed responses to both motions.
Interesting.
And the respondent has filed a reply as well.
To
So
both?
I think the pleadings, yes.
Okay.
So the pleadings are in.
Great, thank you. Let me check on that. In any event, I think we'll follow what's our normal practice, which is to resolve motions of that nature during the course of our resolution of the proceedings themselves. With that, it looks like this is a case where disciplinary counsel, you filed the first brief and filed the reply brief. It looks like it would make sense for you to argue first. I don't know if you've talked amongst yourself or if anybody has a different view. If so, please let me know.
No, that's fine.
Okay. Finally, before we get going, as everybody knows, we're on Zoom. At this point in the pandemic, I may not need to say this, but audio can be weird with Zoom. So during the oral argument, it helps us quite a bit if we can ask questions and have folks answer them or respond to them. So if you see a board member with a hand up, Zoom makes it a little bit tricky to interrupt. We will raise our hands. So if you see a board member with a hand up, we would be grateful if you would kind of give us a chance to ask a question because it really helps us quite a bit with our decision process. And if you are not talking, please mute yourself so that we don't have the other kind of Zoom audio weirdness. With that, Mr. Link, you've got 20 minutes. How much time would you like for rebuttal?
5 minutes, please.
Excellent. So I think, Mr. Turner, as soon as you're great, we've got 15 minutes on the clock. Mr. Link, please, whenever you're ready. Thank you.
Thank you, Mr. Chairman and members of the board. Miles Link, appearing for the Office of Disciplinary Counsel. As a preliminary matter, disciplinary counsel's view is that the issue properly before the board in this matter is disciplinary counsel's exception to the hearing committee's decision that the specification of charges be dismissed on the grounds that respondent's violation of Rule 4.2 had not been proven by clear and convincing evidence. This is an ultimate finding of fact and conclusion of law, and therefore should be reviewed by the board de novo. Rule 4.2a states that an attorney shall not communicate with a person when that person is, quote, known to be represented by another lawyer, close quote, without that other lawyer's permission or consent. With respect to knowledge, Rule 1.0 subparagraph F provides that, quote, a person's knowledge may be inferred from circumstances, close quote. In this case, Ms. Wagner's knowledge that MD, the subject of the conservatorship, was represented by counsel is confirmed by the circumstances in the case before her meetings with him, the second set of meetings that she had. Respondent was
May I
retained
interrupt
by
on
the-
that? May I interrupt on that? I just want to clarify. Is ODC conceding that the first two meetings that occurred before the April 11th hearing, where Ms. Wagner was present, that's my understanding, the two prior meetings are not, you're no longer challenging those as a violation of the rule?
I don't think we ever challenge those as violation of the rules, Ms. Pittman. And as we said in our brief, there's a difference between the absence of knowledge and the avoidance of knowledge. She did not, she can plausibly say she did not know before April 11th that MD was represented by counsel. But after the hearing on April 11th, she could not say that, because at the hearing on April 11th, she was told by Mr. Brett Cohen that he was representing MD. She was told by the conservator who'd been appointed by the court that Mr. Cohen was representing MD. And the judge in the case who was supervising the conservatorship addressed in open court on the record Mr. Cohen as counsel for MD. Those facts are uncontroverted. And we know that respondent.
Mr. Link, excuse me. So going back to your initial comment on standard of review, what actually do we review de novo? The facts that you're now starting to go through with us, seriatim, do we review those de novo, or is it something else that we review de novo? Can you enlighten us on how ODC is viewing our obligations in looking at the facts in this case?
Yes, in essence, what the hearing committee did is say that with their conclusions that you're reviewing de novo, because there's not, as I understand it, a lot of dispute as to the facts. It's the conclusions you draw from the facts that her actual knowledge, they're saying a reasonable attorney might have been confused because of the docket entries, which I'll come to in a minute, and therefore she, as a matter of fact, was confused. We don't think that follows. We don't think there was any confusion here. We think that respondent, in fact, has attempted to show ambiguity and confusion in order to justify her conduct, but it doesn't fit. The April 11th, 2016 hearing confirmed who was the attorney. Now, respondent may not have wanted that reality, but respondent was at the hearing. She could have questioned it before the judge. She could have asked for clarification. She never did that. Instead, after the hearing,
Mr.
Yes.
Can I jump in on a housekeeping matter? Mr. Turner, it looks like the clock has disappeared from our view. If I could ask you to turn however it works so that we could see the clock again, I would be grateful. It doesn't have to be right away. Soon would be nice. Sorry, Ms. Sargent, please go ahead. Sorry about that.
So just to put a fine point on it, you're essentially saying that the hearing committee's actual facts are accepted. The facts that it lists as established are accepted. And you're saying based on those facts, the conclusion should have been different.
Yes, the conclusion, absolutely.
Yeah, and then you can mull this question over. The rule itself with regard to communication with representation of represented party, is it incumbent on the attorney initiating the communication to establish or to have a comfort level that there is no representation? Is that a burden of proof kind of thing that's relevant in any way to the clear and convincing standard? And the reason I say you can mull it over is because if you don't have the answer ready, you can continue with, the argument you were making, but maybe at some point kind of leave that in.
Ms. Sargent, yes, we will come back to that point because that is a very important and very relevant point here. What I was trying to point out was that on April 11, rather than raise this issue with the court, the respondent went to the docket went to the clerk's office, looked at the docket, saw docket entries that had been written 8 months before on September 15, 2015, and because of an apparent inconsistency, concluded that there was ambiguity and that the attorney either had not been appointed or the appointment had lapsed. That completely disregarded what she had seen and heard at the hearing on April 11th.
So can I explore a little bit the Rule 305? So I've got it in front of me, and it says the appearance of counsel for the subject of the intervention proceeding shall terminate upon the disposition. And then the last part says, unless otherwise ordered by the court. Are you saying that at the April 11th hearing, the court ordered the continuation of Cohen as an attorney?
I'm saying that one of the notes on the September 15 indicated the court had already done so. And at the April 11th hearing, the court treated the appointment as if it had been made. The court treated Mr. Cohen as the attorney of record. Whether I don't know that a transcript of that hearing, whether the court at the hearing, he addressed Mr. Cohen as the attorney of record for MD, and that was on the record at that hearing.
So let's say that factually, the judge did not explicitly say at either the September 30th hearing or the April 11th hearing, Mr. Cohen, I'm continuing your representation. But instead, at both hearings, addressed him as the attorney, and when setting up follow-up deadlines and court hearings, et cetera, asked him to continue to participate. Are we to then treat that as a court order ordering his continued representation? Or should we be looking for something more explicit?
Ms. Pittman, the question is, the judge treated it as if he had made a court order. Now, if another attorney had a question, who should they have addressed that question to? They should have addressed it to the judge. And in fact, the respondent after the hearing thought that Mr. Cohen was still the attorney, because on April 13th, when she filed her pleadings, she copied Mr. Cohen as, quote, attorney of record. And her testimony before the hearing committee, she said, question, this is at page 305 to 06 of the transcript. So as of April 13th, you were accepting his representation. He was counsel. Answer, yes, I was, yes. Question, then within 3 days, up until April 16th, when she visited MD again, you had changed your mind. Is that your testimony? No. At this point, I'm not sure whether I was still waiting. I think I was probably, this is 3 days, I think I was still waiting. Now, by this time, I filed the next pleading or visit with Mr. Dan, she mentions his name again, I think I had a different attitude. The question is, she knew what she had seen and heard. And then she decided to create an ambiguity. One of the reasons.
So the short answer, so just to make sure I understand your answer. Your answer is we don't need to look for a writing. You think that 305, unless otherwise ordered by the court, can be a non-explicit order, more of a implied order.
Yes, Ms. Pittman.
Okay, and then I think Mr. Walker has a question. So I just want to.
If I can just finish the answer just for one moment. We know that Superior Court judges routinely issue orders orally from the bench. That this board knows that, the board members, this is not unusual. And 305 simply says an order, it doesn't say it has to be written.
Mr. Link, but respondent takes the position that by operation of law, after that initial hearing, appointment terminates possibly. Do you have a position on that? And do we have to make that decision to continue through the analysis in this case?
Well, I think
may I just follow up because it follows on Ms. Cassidy's question. A disciplinary counsel says in its brief, the expiration of an appointment does not mean a representation has ended. It relates only to the origin of the representation and possibly the means of compensation. Do you still stand by that point? Is that of relevance here to your answer? And if you do stand by that point, what is the mechanism through which the representation continues, notwithstanding the end of an appointment?
Well, the point of that statement is that an appointment can be continued, or a party can, or an attorney can be reappointed. And so here, the representation continued and the attorney was reappointed by the court. We know that because on April 11th, the court indicated that in the hearing. And we know that respondent accepted oral appointments because in finding of fact 81, in the hearing committee's report, quote, respondent regarded the probate court's oral statements at the June 1 hearing at Raphael House as a court order that Mr. Cohen was MD's attorney. Well, that's great as of June 1. As April 11th, the court was, now by June 1, the court knew that respondent had an issue as to whether or not Mr. Cohen. And so therefore, the court knew it was important to clarify that point. At the April 11th hearing, the court did not know that because no party had raised that issue before the court. Mr. Tappan, the conservator appointed by the court, understood Mr. Cohen was MD's attorney. Mr. Cohen understood that he was MD's attorney. The judge understood that Mr. Cohen was MD's attorney. The respondent was at that hearing and did not raise an issue. Now, it could be argued, well, she didn't, she accepted that relevance, but after she looked at the docket sheet and felt that there was some ambiguity there, she then had an opportunity to raise it with the court. For example, when she filed her pleadings on April 13th, she could have raised it then, she did not. It was clear to everyone in the proceeding other than respondent who was the attorney of record for MD. And the reason, with respect, the reason why respondent did not address this is because she wanted to talk to MD on her own. She did not, and she wanted to avoid having to ask for permission because she understood permission would not be granted.
Mr. Link, can I ask a question? So, slightly different direction. In this case, I think from your brief, you're seeking an informal admonition.
Yes.
Assuming we agree with you that there was a 4.2 violation. And my understanding, the hearing committee did not have the sanctions portion of a hearing to hear mitigation and aggravation. What if we agree with you that there's a 4.2 violation? What are we supposed to do? Are we supposed to send it back to the hearing committee for that proceeding, or send it to a different hearing committee? Are we able to find that, you know, there should be because an informal admonition is as low as it can go when there's a rule violation, that we can just sort of like sign off on that and send it up to the court? Like, what are we supposed to do?
Mr. Chair, a great question. I think it's clear the board has the authority to enter a sanction in this matter. An informal admonition is, as you point out, a minimal sanction. What's really important?
That seems like a really efficient process, and I applaud efficiency. You say it's clear we have the authority to do that. How is that clear to you?
Well, I can't cite to a board rule, but if the hearing committee were to recommend a sanction, that would come to you for approval. You could always ask parties to brief if you wanted a separate briefing order as to the sanctions, and we can do that. I think that would be efficient. But I also want to use that question to sort of point out to the board what's important in this state. We are not seeking, we're seeking an informal admonition. What's important here is to send a message to the hearing committees and to the bar that you cannot avoid your 4.2 obligations by simply seeking to avoid what is clear as to an appointment. That this is an issue which is not sort of specifically addressed in 4.2, and it needs to be addressed, because if this board determines that searching for self-help remedies to avoid the implications that you've heard when an attorney is representing another party, particularly when the attorney is appointed by the court, that would send a terrible message to the bar, and this then would not be the last case when that comes before the board, and this would be cited as authority. So it's important that we get this right, because it's important that the ameliorative function of discipline be applied in this case.
Okay, thanks. Ms. Wagner, you've got 20 minutes. If you could thank you, Mr. Turner. Thank you, Mr. Link. If I could ask you to mute yourself now. We're having a little technical difficulty with the clock, but it looks like the time is running. It's just the visibility is compromised. I'll sort of keep a watch. I'll set a timer myself in case we're having trouble with the clock. But Ms. Wagner, I suspect we're going to give you the time to say whatever you need to. So with that, you've got 20 minutes. Please.
I'm going to approach this by assessing disciplinary counsel's argument. In terms of what is important to the bar, it is important that the law be reliable. The law says that a court appointment, this is not a privately retained client, a court appointment requires a court order. Creating ambiguity about that is problematic because every lawyer who wants to do a thing.
Create ambiguity about that?
I'm sorry?
How does disciplinary counsel's position create ambiguity about that sort of basic proposition?
Right. Disciplinary counsel takes the position that Mr. Cohen could step before the court, announce that he is the attorney without a court order, without disclosing to the court that he has no court order, and then proceed to become the attorney.
Well,
Because
Ms. Wagner, excuse me, Ms. Wagner, how else would Mr. Cohen have ever appeared in a guardianship matter of this nature unless a court had appointed him to do so?
His court appointment ended on September 30th, 2015. He showed up in April of 2016 on his own.
So we
Now-
have, in order, I just want to try and understand this, in order to accept this argument, we have to accept that the judge did not know that he was no longer an appointed lawyer, that the judge was fooled.
I believe that to be true. The
Ms.
judge,
Wagner, I'm sorry. On April 11th or April the 13th or April the 11th was the date of the hearing.
right,
And at that time, Mr. Cohen was participating in the hearing in the role of counsel for MD. Is that correct?
he represented himself to be the counsel for MD
And the court responded to him as if he were counsel.
because it was not challenged.
And you were there, you observed all of this.
But I was not allowed to participate.
The 2 days later, you filed papers and
Yes.
you served Mr. Cohen as attorney of record for MD.
Yes.
Okay.
And I did so because Mr. Cohen had represented to me that he had an order, which
So
he was going to send to me, which is why I kept going back to the record.
right. So let me just ask you a similar question to what I asked Mr. Link. The hearing committee's findings with regard to Mr. Cohen's appointment, April 11th hearing, your actions in serving him as counsel of record and so forth, those crucial findings, I know you filed exceptions, but essentially you agree with the findings that were made. Is that right?
Yes.
All right.
Yeah.
And what you're asking for is that this board sustain the conclusion that you didn't violate the rule prohibiting contact with represented persons. Is that what?
Yes.
All right. So thank you for that.
And I'm doing so.
So Ms.
Okay.
Wagner, I thank you. I just want to follow up on, I think what you were saying before. Are you saying that is it your position that at the April 11th hearing, Mr. Cohen appeared as counsel for MD having no authority to do so?
Yes.
And in that case, the court, as Mr. Link recounted for us and the facts suggest or make clear, the court engaged with him up to and including setting a new date for him to return on the matter, correct?
There was a new date set for everybody to return, including me. So it wasn't
Okay.
special to him.
All right, well, okay. So would not, if Mr. Cohen was there with no authority to be there as counsel, would not we have expected to see something in the record with the judge saying to Mr. Cohen, why are you here? On what authority are you here? Have you entered your appearance? Because that's what one must do prior to representing themselves as counsel for a particular party.
Two things happen. One, the court has faith that lawyers speak the truth. He accepted what Mr. Cohen said. Indeed, on April the 11th, I accepted that Mr. Cohen had a court order because he told me he did. And I expected for him to produce it. So Mr. Cohen misrepresented the facts to me, and he misrepresented the facts to the court. Both of us, both myself and the court, stood silent in reliance on Mr. Cohen having an order, which he did not have.
But Ms. Wagner, if there was such an order, wouldn't it have been this court that issued that order? So should not the court know whether it issued an order or not?
Well, experience has taught me that the court doesn't necessarily remember every case that it handles. So there's a need to look back at the record, which is why in this case, when Mr. Cohen first told me, I am Michael Daniels' attorney, I said to him, the court order that I have says that you are not, because your appointment was not continued. His response was, I have another court order that came later. So I said, okay, fine. Then will you send me a copy? He said, yes, I will. So when we stood before the court on April the 11th, I'm standing silent in reliance on Mr. Cohen's representation. He's sending me an order. The court is standing silent on Mr. Cohen's representation. I am the lawyer. Mr. Cohen is misleading both me and the court at that point. But I will acknowledge, I don't know that Mr. Cohen realized he was misleading the court or me on April the 11th. I was looking at the court order. I was looking at the record. I don't know that Mr. Cohen looked at the record. I know that the court did not, because I was in the courtroom, and he did not. The judge did not look at the court file. He relied on the parties to review for him the status of the case. Had the court looked at the court record, had the court looked at its own order, it would have asked Mr. Tappan, where is your conservatorship report, which I ordered you to file by today? He did not ask any of that, but he did not. The court order said you are not to move Michael Daniels from the District of Columbia without prior notice and a court approval. The court did not ask about that either. The court did not look at the order. The court relied on counsel being honest and truthful with him.
Ms. Wagner, the September 30, 2015 docket entries that you're relying on, there was a docket entry, was there not,
Yes.
instructing or indicating that Mr. Cohen was to reappear
Yes.
in this case?
Yes.
And how is it that you took it upon yourself to disregard that entry and choose to just give credit to the entry that said, and it might have been a pro forma entry that said his appointment was terminated? In other words, on what basis did you choose, and weren't you put on notice there that, well, he may be the lawyer? Now, maybe you've addressed this already, but I don't understand how.
To speak to that.
Yeah.
I'll be happy to speak to that. The court docket is recorded in ascending order. The earlier events are at the bottom, the newer events are at the top. I don't doubt, as Mr. Cohen has suggested, that there may have been some discussion after the hearing. It was not on the transcript. The transcript did not show a reappointment about Mr. Cohen continuing. That possibly happened. I cannot know that. I cannot make a decision based on that. The rule is talking about what I knew. What I knew was that the court, that there was an indication that there was a thought for him to continue to be reappointed. Subsequently, there is a docket entry that says he is dismissed. But the more important point is that subsequently, the court confirmed he is dismissed with a court order that does not continue Mr. Cohen's appointment. His signature is on it. It's dated, it's filed, it's docket. That order controls. Mr. Cohen's thought that he was appointed.
Ms. Wagner, are you talking about the two docket entries?
I'm talking about the two docket entries and the court order. If you look at the docket entries, you see first a discussion about him continuing. You see second, he is dismissed. And you see third, a court order that makes it clear on the face of the order, his appointment was not continued.
Where is that order in the record? Can you help us? Where is that order in the record and what's the date on it?
I believe that order is DCX 10, but I'm doing that on memory, so I could be wrong.
My memory of that is that it's a form order and the judge did not check off continued counsel and then write the name. Is that right?
Right. And whereas he did check off the other entries where he made appointment.
Can I ask you a follow-up question then, which is that, do you agree with, I think, the hearing committee report and Mr. Links that the June 1st hearing, Cohen was ordered by the court to continue as counsel?
He was, and we did not.
And that was not done in writing. That was done orally?
It was done orally and explicitly.
Okay.
It was not done vaguely. It was not implied. It wasn't Mr. Cohen appointing himself. Mr. Cohen, in fact, asked the court, and the court responded. He did not do that on April 11th.
What is your sort of best case support or legal support? It doesn't have to be case, legal support that the order under Rule 305, unless otherwise ordered by the court, has to be either in writing or explicit?
The rule itself says shall. It doesn't say, it's not vague. As lawyers, we know the meaning of the word shall.
And then it immediately has the clause of unless. And so I'm just wondering that unless clause.
Shall terminate unless ordered. There is no order. So shall terminate applied. In the absence of an order, the appointment terminated. And the statute was the court rule is quite clear about that.
Okay.
Other question.
Ms. Wagner, who did you? I'm sorry. Was someone else trying?
No. You're.
Ms. Wagner, who did you represent in the Superior Court in this matter?
I represented Michael Daniels through his brother. What happened was initially I knew the family. So my initial visit was at the brother's request. They asked me to, because Tappan would not share his location. And they didn't.
And just to be clear, we should refer to the person at issue as MD, right?
Well, I'll say this about that.
If we could just refer to the person as MD, and maybe we don't need to, but it seems safer than not.
Well, Mr. Daniels died on May the 8th.
Well, still, let's go with MD.
We can refer to him as MD if you wish. I'll try to remember that. I mean, because I knew him personally, it comes. But I've lost my track now. What was the question?
The question was, who did you represent? You said you represented MD. I think the chair is correct. We should refer to him as MD.
Okay.
Where in the record did you make clear, on the record in the proceedings below in Superior Court before Judge Fisher, where did you make clear that you represented MD? The record appears to establish that you represented MD's brothers and that you were retained by MD's brothers.
I was retained by MD's brothers to represent MD. Now, in terms of, well, let me finish now. The record shows that in a motion, because that became a contentious issue later, when we filed a new petition, and that the new petition was filed actually by the brothers, and we were not able to communicate with MD.
I'm sorry to interrupt, but did you say you were hired by the brothers to represent MD?
Yes.
Were you not also hired by them to represent the brothers' interests?
The brothers didn't have an interest other than to see that Michael's interests were before the court.
Well, my
my
question was, weren't you also hired by the brothers to represent them?
No, not really, no. My role, they hired me to represent MD. They asked me to go visit MD to determine, did MD know that his house had been cleaned out? Had MD's position changed since September 30th, when he told the court his intention was to remain in his home with assistance.
May I interrupt? Under what authority do the brothers have to hire a lawyer for MD if MD is now going through this petition process?
And has a guardian ad litem.
I'm sorry, is that a question?
Well, Andy has a guardian ad litem, right?
Right.
Now, at the point that I'm in the case, he does not have a guardian ad litem.
No, he has a guardian. So he has a guardian. And so I'm just wondering, so we've got this petition filed, he's gotten a guardian appointed. So what authority do the brothers, who have not been appointed as guardian, have to hire you as MD's attorney?
The brothers, one, are participants in the proceeding. Two, the law gives them standing as the next friend. And I cite the law on that in my brief, in my proposed findings of fact, all the way through, I've noted. The brothers come in to represent MD, who is able to advocate for himself. He is blind, he cannot get around, he cannot read, and his opponent is the guardian fiduciary, who is not exactly going to step up and sue himself. So the brothers' participation was required in order to have MD heard.
So can I raise a question, which is that when I trace back the arguments that you made in your brief before the hearing committee, and maybe I'm wrong, please correct me if I am, I read that you were representing MD's brothers, and that the argument that you were representing MD comes, what appears to me, for the first time before this board. So we're reviewing the hearing committee's findings and conclusions. Can we accept a new argument like that? And if so, do we have sufficient findings to do so? Because I don't know that the hearing committee considered that as an argument and the potential conflict.
That was argued before the hearing committee, and it's in the transcript. The question that question came up, I believe, in the hearing. But at any rate, I know that I told the hearing committee that I was representing MD through his brother. In fact, disciplinary counsel questioned me on it in an attempt to try to confuse the issue, and I was quite clear about it. I can certainly get the page number to the board following the hearing. I don't know them off the top of my head, but it's not a new issue. No.
And is it in the record somewhere, your written representation agreement?
No, that because that never was an issue before the committee. My testimony is there. The agreement, as I recall, was by email, and nobody ever asked for the document. So the retainer. That was not a question that was raised.
Okay, and Ms. Weiger, didn't Mr. Tappan, who was the guardian, did not he seem to understand that Mr. Cohen was the attorney? In fact, he would serve Mr. Cohen, documents necessary for the conservatorship. Was that not going on from September through April?
That was going on for quite some time. What I need to explain about that is everything, all court filings now are done electronically. When you go into the court portal to file a pleading, it automatically populates all of the parties who were at the last hearing. You can't take them off, because when you try to take them off, the clerk rejects your pleading.
Excuse me, I understand your argument that you're making, that it was just if Mr. Tappan was filing pleadings or updates, they were getting automatically populated to everybody who was at the last hearing, but did not Mr. Tappan.
He's on his certificate of service.
But did he not testify at the hearing that he too understood Mr. Cohen was counsel for MD?
Mr. Tappan's agenda was to get me out of the case. So he raised the issue of 4.2 before Cohen said anything. In fact, Cohen did not raise it until Tappan called him. So the whole issue of 4.2 arises because Tappan wanted me out of the case. I had filed a petition regarding his breach of fiduciary duties, and I was seeking damages. Mr. Cohen's pleading make it clear, particularly his reply to my opposition to his motion to strike, that the agenda is to remove me and to remove my pleading.
So, Ms. Wagner, you're out of time. Thank you very much. Mr. Link, I believe you reserve 5 minutes for rebuttal. Please go ahead.
I did. I think it's important to note something my learned friend said, and that is, in her view, both the judge and Mr. Cohen and presumably Mr. Tappan were all mistaken when on April 11th, they thought Mr. Cohen was still counsel. Presumably Mr. Cohen came to the hearing, came to the court, participated in the hearing under some misimpression. Presumably the judge recognized him as an attorney, as the attorney of record for MD, under some misimpression of his authority and the law. Ladies and gentlemen of the board, that's a lot of suppositions which simply are unsupported by the record. Respondent was retained on April 5th by the brothers of MD to represent them. They had an interest in seeing what was happening to MD. No one disputes they had an interest, but they were her clients. Respondent subsequently tried to get represent MD, but that was subsequent. She was retained, and that's why we point out in our brief, there's this potential even conflict of interest in the dual representation. The reason why the judge was explicit on June 1 was because by June 1, everyone knew that respondent was contesting Mr. Cohen's appointment. And so the judge wanted to make it clear that's done. At the April 11th hearing, no one contested it. And respondent and finding of fact number 46, at the April 11 hearing, when Mr. Cohen sought to waive MD's presence, respondent objected. Now, her objection was overruled, but she did participate to that extent. Why, toward the conclusion of that hearing, she didn't raise an issue if she thought there was an issue about Mr. Cohen's representation, I don't know. Why on April 13th, when she filed her pleadings with the court, she didn't raise this, I don't know. This is not about a duty to inquire. This is about a responsibility to resolve. In her mind, and only in her mind, was there some ambiguity or confusion about who was representing MD. Everyone else understood who was representing MD.
Isn't that enough, Mr. Link, if it was in her mind?
No, not.
Why isn't that enough to defeat proof of knowledge?
Because under 1.0F, the circumstances surrounding the knowledge, the circumstances determine the extent of your knowledge. With respect to circumstances, and that's there. I'm sorry, can you hear me?
You muted yourself briefly, but you're back now.
Okay. And the reason why that's there is to avoid just a situation where an attorney seeks to say, I didn't know. The circumstances on April 11 were clear. And if there was any question, the person to resolve it was the judge, just as the judge did on June 1. And she never raised it then. And she went ahead with her meetings, and she did so without raising the issue because she didn't want it resolved, because she wanted to meet with MD on her own. Ladies and gentlemen.
Can I ask one just clarification? So I don't think it's fair to say that she should have raised it at the April 11th hearing. She hadn't yet looked at the docket. She didn't see that there was the court order that didn't check off counsel continued and the conflicting docket entries. That came later. And so my question to you is, between when she looked at the docket and the record on April 11th after the hearing, and she sees, oh, there actually isn't a court order appointing him, not a written one at least, right? Yes, there was these oral presentation and he seemed to be accepted by the court as the lawyer. But what if there really was being a fraud being perpetrated on the Superior Court here? She's got some documents that say he's not really the lawyer. Are you saying that 4.2 obligates her at that juncture to go back to the court and say, I see all these conflicting things. You accepted him as the lawyer orally and in person, but your written record says otherwise. Please clarify this.
Ms. Pittman, there is authority in this jurisdiction, and we look in our reply brief on pages 13 to 16, we discuss the limited case law and reports from the board on this issue in terms of when a duty to ascertain obtains. The circumstances here on April 11th at the hearing were clear. Everyone said Cohen was representing the respondent, so that was clear. And remember, those court entries, those entries on the docket sheet were 8 months old. So you're relying on 8 months old docket entries to contradict what you saw today before the hearing. But if I take your point, she found those docket entries after the hearing had concluded, she served papers on the parties on April 13th. Why? This could easily have been one of those papers. Here, the issue before us is when the circumstances are clear, when everyone who is responsible in this proceeding, the guardian, the judge, the other attorney, argue to you that this person is represented by counsel, can you ignore that based on some 8-month-old notations on a docket sheet? With respect, the board can't conclude that simply is an unreasonable, and the argument that there was a fraud on the court, that's,
to be fair, that was something I said.
Well, okay. That would require, I'm speechless, and as you know, Ms. Pittman, I'm not usually speechless. But the board often hears very complex cases dealing with difficult facts and difficult legal issues. With respect, this is not one of those cases. We urge the court to find that respondent violated Rule 4.2 and the sanction should be an informal admonition. The board never defers to the hearing committee as to sanction. The board makes its own determination. This is an appropriate case to do so.
Okay, thank you very much. Thank you, Mr. Link. Thank you, Ms. Wagner. The case is submitted.
Thank you.